Council. We'll call the first case on the morning docket, 103373, Wrinkle versus Norman et al.
My name is Stephen G. Dickerson, appearing this morning for the Dickerson Law Group on behalf of the plaintiff appellant. This appeal has been allocated 20 minutes of oral argument. I would respectfully request 8 minutes of rebuttal with 12 minutes of my primary opening argument.
All right, thank you.
This is an interesting personal injury case in which there was a rush to judgment, more specifically a rush to summary judgment in the district court and in the Court of Appeals that has deprived the plaintiff of an opportunity to present his claim to the fact finder, to the jury, and be heard and have the case determined on its merits. The well-known and established rules of summary judgment were simply not faithfully adhered to in this instance. All as I hope we'll have a more fuller opportunity to discuss, at least briefly, this morning. This is an unusual fact pattern. I know the court is conversant with the facts, so I'll not spend any time initially addressing them. The first,
I have a fact question.
Sure.
What was the evidence that these cattle belonged to Mr. Norman?
Yes, this was a question that was raised in the Court of Appeals. There are multiple facts and inferences to be drawn from the record in that regard that I believe persuasively support presenting the issue that you've raised to the jury. First, Mr. Wrinkle was a neighbor living across the highway from the defendant. He believed that the cows that were out on the highway belonged to the defendant. When help was summoned later in the day,
He indicated he had seen cattle there before, but my recollection is that the particular calf that ended up tripping him up, he was unable to describe it. And so his testimony was that he had seen some cattle on this premise, on these premises at some time prior.
He had seen cattle on the property prior, but what we have here, Judge, is not a situation where we have an unattended cow out on a highway. It's struck by a vehicle. There's resulting injury or property damage, and no one steps forward to acknowledge ownership of the cow. What we have in this instance is 5 cows out in this yard next to the highway. They're ran back into the pen, into the pasture. The gate secured, which was open when the gate was first approached by Mr. Wrinkle and his friend Mr. Lee. And then there is no explanation provided by the defendant as to why, when he comes home from work an hour or so later, there are at least 5 cows in his pasture when he insists that 2 days before he'd removed all of the cows from the pasture to another location. And so at some point, there are some compelling inferences that seem to flow from this fact pattern. If he comes home and he has 5 cows in his pasture when he insists that he had none as 2 days earlier, then what does he do about it? Does he call a neighbor? Does he call law enforcement to say, hey, I've got cows in my pasture that are unexplained? He does nothing. There's a compelling inference there that the cows were his.
Was he directly asked that during the discovery process?
Yes, he was asked in a series of questions in his deposition, some of which are referenced in, I know, the petition for review, at least one passage. Did you have any cows in your pasture in March of 2006 that weren't yours? He said, that never happened. I never had any. I never came home. I never had cows in my pasture that were unexplained. It did not happen. He was very insistent about that. There are like 3 questions that were posed to him in that regard. His wife was also deposed, and she deferred really to him and shared little insight about the status of the cows.
Let's even back up from your position that he's not a trespasser but a licensee and invitee and has that status. What exactly is your theory of negligence? Is it leaving the gate open? Is it the clothesline? Is it a combination? What exactly is it?
It is a combination of the two. First, the gate was left open. It was found open. And we have a couple of Kansas cases in which the case went to the jury, and it was unclear, or there was no unequivocal proof of how the animals got out. But here we have an open gate, and so there is a means of escape. The gate should not have been open. The gate had absolutely no mechanism for securing it. There was no lock, there was no chain, there was no wire. The cows had been out in the past. This is another fact consideration from several earlier Kansas cases in which if there's been a history of cows or horses or animals getting out, that can be important for a jury in sorting out whether there was negligence or not.
But once the cows are returned to the pasture, if that's indeed accurate, I mean, there's no showing that's how the cows escaped in the first place. It could have been somewhere else, or if that's where they came from. Wasn't that cured by his bringing the cows back? Doesn't that break any kind of causal connection to your negligence once the cows are returned? Well,
the injury occurred in the process of returning the cows to the pasture. So there are 5 cows. They are shooed up along the house. The gate's open in the back of the house. 4 run in the gate. 1 gets caught in this clothesline wire that's hanging from a clothesline pole and laying across the ground. The wire wraps around the cow's neck. The cow is strangling, according to the testimony, choking. The plaintiff makes an effort to take the wire and to flip it in a way that will free it from the neck of the cow. He ultimately does that. The cow runs to the open gate, but one of its feet catches the wire, pulls it taut, and flips him up there.
Is that even at all remotely foreseeable, the proximate cause of his injury? I mean, you're a property owner and you happen to leave there's no evidence as that. Your client can't say how the clothesline was left, assuming it could have been hanging from, there's no evidence as to how it was left, just that the cow got entangled in the wire, in the clothesline. How is that a condition that would leave someone responsible for negligence and lead to damages?
Well, it's a fact question. If someone leaves a wire running across their yard, and the testimony was that it was partly looped in some big loops hanging from the pole, but the other end was running out across the yard. It is reasonably foreseeable. There is a risk of harm that could be associated with that. There was a playground set in the
Isn't there a
corner of
risk
the
of
yard.
harm in any clothesline?
I'm sorry,
In any clothesline, there would be a risk of harm. It's a wire going across a yard.
this wire was not hanging. It had been taken off of one pole, and it was just hanging off of the second pole partly, and then laying out across the ground. So it wasn't stretched between two poles. That's not what happened. The wire is laying across the ground.
I think what we're trying to get at is the condition of the wire doesn't appear to be the proximate cause of Mr. Wrinkle's injuries. That if the calf hadn't become entangled in the wire, the condition of the wire would not have caused injury. The intervening event was that this animal gets in the wire and Mr. Wrinkle tries to extricate it.
That's why the two events are certainly interrelated, and I don't want to suggest that they aren't. The cows being out running loose in the yard with wire laying across the ground presents potentially a risk of harm. We haven't.
Would that have been true for any piece of property on Mr. Norman's property? Let's say there was a shovel sitting out, and the cow would have run over the shovel, and the shovel would have come up and hit him in the head. Would that satisfy a fact question to bring to the jury? I mean, it seems like any ordinary piece of personal property in our imagination could ultimately cause injury in this scenario.
That may be possible, and there are a spectrum of scenarios in which we could visit about, certainly, and some at one end and some others at the other end. But the reality is, we're leaving wire laying out across a backyard, and there are a lot of scenarios in which someone could get tangled up in the wire, whether it's a cow that precipitates the event, or kids running across the lawn, or a lawnmower.
There's no evidence as to what the clothesline wire was, where it was located, where it was at, how it was at the time of the.
There are photographs
afterwards of showing it hanging up on the clothesline pole.
Yes, but it gives you a general presentation of where it was on that day, although it was laying across the ground.
You say it was.
Yes, well.
There's no evidence that it was. He didn't see it.
Well.
He did not see the wire. Mr. Wrinkle did not see the wire. The only time he came in contact with the situation was when he tried to extricate the cow from the wire. He didn't know where it was or what it was like.
That's true. That was his first encounter with the wire, but he picked it up off of the ground to begin flipping it or whipping it to free or to extricate the cow. I observe that my time is up, and unless there are other questions at this point, I'll defer to the defendant.
All right.
Thank
Other
you.
Questions? Thank you.
May it please the court. Robert J. Luter, Bob Luter, on behalf of defendants Gene and Charlene Norman. It's a pleasure to be here today. First of all, I would like to comment on something Mr. Dickerson said about this theory that the Normans should have realized they had 5 new cows in their pen after the fact, and that leads to an inference, allegedly, that these were their cattle. That really wasn't delved into in the court below, and it really wasn't presented to the trial court before summary judgment was issued.
Help me understand, on the summary judgment motion, was there a statement of uncontroverted fact that these cows were not the Normans?
There was a statement of uncontroverted fact to that effect. Gene and Charlene Norman offered in deposition that they had moved cattle entirely off of their property in early 2006, before this incident ever took place. What we are dealing with, Your Honor, is a lot of kind of tangential inferences drawn by the plaintiff. Mr. Wrinkle testified he thought it was their cattle. He saw the cattle in their yard.
Let me just understand the procedure first. So you make a statement of uncontroverted fact that the cattle did not belong to the Normans. I assume Mr. Dickerson responded controverting that fact. And what did he do in that statement to controvert?
Well, as I recall, there wasn't anything direct. He testified in deposition that he saw the cattle in their yard and thought it was their cattle. And he also saw an open gate, and the cattle started to run through that gate when he started to try to herd them back there. But there was nothing direct saying, yes, these cattle belong to Gene and Charlene Norman. Again, the Normans testified that they had moved cattle entirely off that property before this incident ever occurred. There also was testimony in the court below, Your Honor, that neighbors of the Normans, also in Oskaloosa, similarly owned cattle. So there was never anything... I'm sorry?
Explain to me then why the presence of the cattle without the Normans denying that those cattle belong to them immediately after the fact doesn't create an inference of ownership.
Well, he can argue that it does. The point I was making initially was it was never really presented to the trial court below. That argument was not.
That's why I was trying to figure out what procedurally had happened.
And it wasn't really delved into. The Normans weren't directly asked in deposition about this issue. They did deny they ever had cattle there in March of 2006, but they were never directly asked, well, what did you do with the 5 cows that were in your pasture after this fact? I don't think it was ever really delved into.
So isn't that enough for us to reverse summary judgment and remand if it's not, if so I understand it, you're telling me he controverted the fact. You may not feel he controverted it very well, but why hasn't that created a question of fact that makes summary judgment inappropriate, at least as to that issue that the Court of Appeals kind of clung to?
On the ownership of the cattle?
Yes.
Well, but still, it doesn't, the fact that there was kind of an absence of dealing with that fact doesn't create an inference that these cattle belong to the Normans. At most, it would indicate, there might be an issue as to what happened to the 5 cattle after this happened. What did you do with those cattle in your yard? But that doesn't necessarily lead to an inference that the cattle belong to the Normans. It's just an undeveloped fact. But again, with regards to all of these factual allegations, we think this thing really devolves back to the duty of care. The really important issue in this case is what was the duty of care. There is no dispute in this case that Mr. Wrinkle had no permission from the Normans to enter their property. He testified he thought he might have been on their property on one prior occasion. There's no dispute that they didn't know he was there. What this man did was he saw some cattle in what he thought was the Norman's front yard, and he and a friend of his, Raymond Lee, went over there. They thought they saw an open gate and started to herd cattle through that gate.
And so your clients think that no good deed should go unpunished.
Well, my clients think that the duty of care doesn't elevate to reasonable care, and that the fact that this man entered their property without any permission...
If it had been their cattle.
I'm sorry?
If it had been their cattle.
Yes.
If he had been correct in that assumption, would he still have been a trespasser when he tried to return them?
I think what the rule of law is under Section 197 of the statement, if this court decides to adopt that, and it's never been adopted in the state of Kansas, what the rule of law would be that Mr. Wrinkle had license or kind of an implied right to enter the property to deal with this emergency situation. But that only means, Your Honor, that he can't be sued for trespass by virtue of doing so. It's a whole different kettle of fish to say that once he does that, suddenly the duty of care owed by the landowners elevates from willful or wanton conduct to ordinary care.
That's 345, isn't it?
It's in 197 and 345.
Well, 197 is the liability of the actor to the landowner, and 345 is the liability of the landowner to the actor that's exercising the privilege. And why wouldn't that come into play? 345 come into play here.
Well, we believe it does, but the court below, the Court of Appeals, interpreted that as not providing that the duty of care elevates from willful or wanton conduct to ordinary care. And we really feel like that's the rub. And I would ask the court to recall that the implications here are far-reaching. If there's going to be a rule that if there's an emergency situation for whatever reason, regardless of if it had anything to do with what the landowner did, and somebody enters the land, by virtue of that alone, that alone, the duty of care increases from willful or wanton conduct to ordinary care, there would be wide-reaching repercussions.
When the writers of the restatement said in the comment to 345 that the person with the privilege, that the possessor owes that person a liability the same as to a licensee, what do the writers of the restatement mean as to the duty that's owed there?
Well, that's hard to tell, Your Honor. I know that the court below found an Illinois case, actually two of them, that applied that regardless of that language, Illinois had similarly eliminated the distinction between invitees and licensees, right, and held that ordinary care duties applied. But the Illinois court held that, look, simply because you have some kind of a right to enter a property for an emergency situation, all that does is eliminate your potential liability for trespass. It does not elevate the duty of care owed by the landowner.
How does the restatement treat a licensee? That was my question.
Well, I think that the restatement treats a licensee as one that's owed a duty of ordinary care. But the restatement's not been adopted by any court in the state of Kansas. And I was elaborating on what the Illinois court did with this.
I understand that, but I'm just, if we were to adopt the standard of care that was anticipated by the writers, I'm trying to determine what that standard of care would be.
Well, actually, I might have misspoke because I think that restatement provision dates back to the 1960s. I'd have to look at that, Your Honor, but I think, come to think about it, the restatement might still treat, or at least at the time still have treated licensees as being owed a different duty of care. I'd have to look at that, frankly.
That's kind of what my suspicion is.
I'd have to look at that. But I know the Illinois courts were more recent, and they said, look, we're not going to elevate the duty of care owed by the landowner. And the point I was trying to make is, let's suppose that, again, the repercussions here are fairly far-reaching. Let's suppose that there's some kind of emergency situation that the landowners had nothing to do with. Somebody's bit by a rattlesnake, and a Good Samaritan passes by, and they want to render assistance to that individual. If the duty of care were to automatically elevate, the landowner suddenly would owe a duty of ordinary care when he or she had nothing to do with the emergency situation. So, any kind of a general holding by this court that once you have an emergency situation, you can enter property, that automatically raises the duty of care would be fairly far-reaching. We think the more reasonable interpretation is what was adopted by the Court of Appeals. Specifically, it gives you a license to enter the property to deal with the emergency situation, but that does not raise the duty of care owed by the landowner. And if we assume that the duty of care owed by the Normans remained willful or wanton conduct, it doesn't matter how the clothesline got there. It doesn't matter why the clothesline got there. It doesn't matter really how the cows got out. There's no inference here of willful or wanton conduct. What the court below held, the district court below, was, look, under this duty of care, there's no inference here that the duty of willful or wanton conduct was breached. So summary judgment is appropriate. If I could move on, the second issue, beyond sections 197 and 345, is this livestock running at large statute. And as you may recall, this statute 47-123 generally holds livestock owners liable for damages caused by livestock running at large. We believe the Court of Appeals was correct in holding that still imposes a duty of ordinary care. It's not a strict liability statute. But we think even more importantly, Mr. Wrinkle's attempted a bit to have his cake and eat it too here. In other words, he's alleged that there was livestock running at large, and we would focus on the verbiage at large, meaning off property. But then he's also filed a premises liability case for damages that occurred to him while he was on the Norman's property. And because of the fact that he had allegedly gotten all the cattle back on the Norman's property by the time of this incident, we believe indicates that the livestock were no longer running at large. They were on the property of the alleged landowner. So really that statute has no application here at all. But
so
also,
you're defining at large as being off premises rather than out of restraint, out of the pasture?
We're defining it as being off premises, and here's why. Because there would be an inconsistency between premises liability law and the livestock running at large statute under any other circumstance. Again, courts have interpreted the livestock at large statute to impose a duty of ordinary care. But when you're on the landowner's property, it's been the law for years, as we all know, that the standard premises liability classifications come into play. And so that's the law that should apply here, is the premises liability classifications. And as we all know, invitee, ordinary care; licensee, ordinary care; trespasser, willful or wanton conduct. So again, though, we think the Court of Appeals was correct in pointing out there was never really any direct evidence that these cows even belonged to the Normans. But even if they did, the fact that the gate was allegedly unsecured really doesn't matter. The fact that there was a clothesline left on the ground allegedly really doesn't matter. The duty of care owed by these landowners was that to avoid willful or wanton conduct. Also, I would point out that with regards to application of the restatement provision, it applies in emergency situations where there is some kind of exigent situation that the Good Samaritan here is trying to deal with. But we would submit, even if this court adopts that restatement provision and indicates it could apply in a general sense, arguably its application had ceased by the time of this incident. Because please recall that under the undisputed facts, Mr. Wrinkle had herded the cattle back onto the property. He claims that he had herded 4 out of the 5 calves back into the pen. There was still one calf left out, and it was away from the highway in the backyard of the Normans. This is all allegations.
But it was choking.
Well,
Didn't a new emergency arise?
well, I don't know if the calf was really choking. He said it was around its neck, and he was trying to free it. And then the calf took off, and the clothesline allegedly caught the back of Mr. Wrinkle's legs and flipped him over onto concrete, is how this happened. But any license that Mr. Wrinkle had to enter that property, any emergency situation, had ceased. So I don't know.
Now, you're telling me that cattle on the highway obviously present a risk, wouldn't you agree? You're telling me that if you run a calf back up into the yard, you've solved the problem?
Well, it was in the backyard of the Norman residence. It was well away from the highway.
And obviously, if they came from that particular pasture, which he thought they did,
Yes.
they would have had to go from that yard to the roadway. I'm just trying to, are you telling me that the problem was solved when he ran it back in the yard and it didn't matter that they were placed back into the pasture and the gate closed?
The problem was solved when the calves were away from the highway in the backyard.
For how long?
Well, he could have easily left the property and made a call to emergency personnel to deal with this.
So the
But-
exigency is what you're saying was resolved
I think the emergency...
until the calf ran back out on the highway.
Well, I think at the time of this incident, as far as the danger presented by the calves to oncoming motorists, that had been dealt with. The calf was well away from the highway in the backyard of the Norman residence. But again, the larger issue here is what was the duty of care owed by the Normans. And we have a situation where we believe at most Mr. Wrinkle had the right to enter the property to deal with an emergency situation, but that does not elevate the duty of care owed by the Normans. So all of these alleged factual allegations or disputes are really irrelevant. And I would also note that as far as the references you've seen in the briefs of Mr. Wrinkle about 911 transcripts, 911 records, those also weren't really presented to the court below before summary judgment was rendered. What we had to deal with was the facts presented, which was that the Normans denied that the calves were there, and Mr. Wrinkle entered the property of his own accord, and we pointed out that the duty of care would apply to, would it be willful or wanton conduct. And that's all I have. Thank you.
Any questions? Thank you, counsel.
Thank you. A moment ago, I did not take the opportunity or have the opportunity to address statutory liability under 47, 122, and 123. I think it is important to note those statutes. 122 says that it shall be unlawful for domestic animals to run at large. 123 unequivocally provides that the owner shall be liable to the person injured for all damages resulting therefrom. We have a multitude or a line of Kansas cases that say that the application of 122 and 123 do not give rise to strict liability or res ipsa liability. There must be negligence. The negligence focus, though, is on whether there was negligence in allowing the livestock to get out of whatever their enclosure was and to run at large. Well, that's what happened here. There is a claim that the animals were running at large. I don't think there can be any serious dispute about that. And that injuries resulted therefrom as a result of the animals being out. And so the question is, under 122 and 123, was there negligence?
Can I just deal with the procedural issue here first? You took exception, at least in your petition for review, to the Court of Appeals finding on the statutory question, but then you never argued it. You just, in your petition for review, you limited your arguments to the interpretation as to whether Mr. Wrinkle was a trespasser and didn't give us any direction as to why the Court of Appeals was wrong.
Well,
in your brief or in your petition.
And that's a misstep on my part because 122 and 123 were presented to the trial court. They were discussed in oral. Those statutes were discussed in oral argument before the Court of Appeals. And as I recall, there's a page limitation on petitions for review. I thought that it was critical to elaborate on the facts in a way that used some of the pages. So I wasn't at all trying to suggest that 122 and 123 aren't pertinent because I believe that they are. And the most recent 122, 123 case, I believe, is the Cooper case. And in that case, there was the same thing. We had a horse getting out, not cows, and we had an unpadlocked open gate. The gate was found open. There was no explanation for exactly who opened it or how it got open or how long it had been open, but there was an open gate, and there was a history of horses getting out. And those two compelling facts alone put the case to the jury. And it's exactly what we have here. There is a legacy of cows, of Norman cows getting out.
If I may interrupt, I'd like to hear your response to the to your opposing counsel's argument that you can't have it both ways, that the injury was caused both by the animals being at large and caused by the one animal that was still loose that got tangled up in the wire on premises.
Well, I don't know that it's. I think it's an unfair characterization to suggest that the plaintiff is trying to have it both ways. I mean, this is a continuing sequence of activity, and as the plaintiff is shooing the cows back into the pasture, 4 pass through the open gate, and 1 gets caught up in this wire, and so I don't know that there's really a distinction that you can make in that regard. It was just a continuing, unfolding sequence of events that were all very related, closely interrelated, in fact. But again, 122, yes, sir.
You have to disagree with the characterization of at-large. Your opponent had indicated once the calves were back in the yard, they were no longer at-large, and the statute didn't apply any longer.
Well, I believe that you made an astute observation a moment ago. I mean, running a cow up 25 yards to the backyard off of the highway, but then letting it go at that point.
But do we have any case law on what it means to be at large for livestock?
To my knowledge, not in the context that we have in this case. I don't believe that we do. If we do, I have not. I have not seen it. A couple of other points that I wanted to touch on very briefly. there's been this suggestion that there's an Illinois case that says that even if this court adopts 127 and 345, and Mr. Wrinkle enjoyed the status of a licensee at the time that he was hurt, that somehow the standard of care, the duty of care owed to a trespasser is what applies. There are a couple of Illinois cases that discuss that. The most recent one is Lang. It's cited in the materials that the court has been provided with. What's interesting, though, in Lang is that discussion essentially occurs in dicta, and the court made two very compelling, persuasive points. Number one, the Illinois court concluded that this wasn't a true emergency, and so 197 did not apply. This was the cab driver who had a fare take off on him for $6, and he ran into a construction site at night. So he's chasing a $6 fare. The second point that they made in that case is that nothing was being done for the benefit of the possessor or the landowner. And they said in those circumstances, should they have applied 197, they questioned the legitimacy or propriety of using a reasonable standard of care. That's not what we have here. 197 and 345, when they're read reasonably, they clearly apply. It's not a Chicken Little situation if the court embraces 197 and 345. How many years of jurisprudence do we have? And we really haven't had this situation presented since the original restatement was published in 1934. I don't think the sky's falling.
To Justice Byers' question, how do we apply both 345, which has to do with premise liability, and 47-123 that has to do with allowing livestock to run at large?
Well,
why do they both apply?
Yeah, I think they do both apply. They can apply alternatively or together. I mean, our rules of civil procedure for years have recognized the right of a claimant to present alternative theories of recovery.
That's what we're trying to get at. Are they alternative or are they simultaneous? I thought your response to me earlier was that this was a sequence of causal events.
Well, I do. I think there's an overlap, and so I'm not trying to retreat from that position.
If they have different standards of care.
Oh, well, if that's the point, I don't believe that there's a different standard of care. It's due care. Most of the cases use due care with regard to livestock running at large. The 122, 123 cases very typically will use due care, but reasonable care is essentially due care.
That contradicts what you argued earlier. Earlier you were saying that the due care involved in the livestock had to do with caring that they don't get out, not a due care to make certain they don't injure anyone. Which is the due care involved under the statutes is you just got to keep your animals in and take what steps are necessary to keep them in. Once they get out, there's no standard of care that's involved with regard to the injury.
Except that 123 says that the landowner, the owner of the livestock, shall be liable for all damages resulting therefrom.
Exactly. But that's not the 345 standard.
No, the 345 standard elevates Mr. Wrinkle to licensee status, and the rule in this case since Jones v. Hansen in 1994 has been that it's a reasonable care standard that applies to both invitees and licensees.
I'm still not sure if I understand. Are you disagreeing with his definition of at large? Are you saying at large just means unpinned and restrained?
Yes, that's all I'm saying.
Doesn't matter if they're on the same owner's property. It's just that they're
It couldn't matter.
Not pinned.
I mean, a horse could be racing, could have been negligently freed from its enclosure and be running to the road, and and a car sees the horse coming and takes evasive action, and somehow the horse turns on a dime and never leaves the property, but the car crashes because it took evasive action to avoid that collision. Well, that's still an animal running at large, whether he had reached the right-of-way or the highway or not, or had stayed on the landowner's property. I mean, I don't think that's a distinction that you can that you can reasonably make.
Other questions?
Yeah, are there any other questions?
Thank you.
Thank you so much.
Thank you to both counsel. We'll take this case under advisement. Call the